All right, this is case number 22181969. This is Stephen Abernathy versus Nationwide Mutual Insurance Company. The matter is before the court, set on for a scheduling conference. This appears to be the first hearing regarding this matter. Your appearance for Mr. Abernathy, please.
Yes, good morning, Your Honor. Connor Clorty, P84485, appearing on behalf of the plaintiff.
Thank you, Mr. Lord, and good morning to you. For Nationwide Mutual Fire Insurance, your appearance at this time, counsel.
Good morning, Your Honor. Jeff Peach, P74754, appearing on behalf of defendant Nationwide.
All right, thank you, counsel, and good morning to you as well, sir. Any progress beyond the need for the court to set this up for some discovery schedule at this time? If you talk or anything that needs to be brought to my attention at this time. Go ahead.
Not that I'm aware of, Your Honor, unless brother counsel has something to add.
But no, Your Honor, just a standard course of discovery would be amenable to us. We just need to have Mr. Abernathy come to a deposition and the usual, nothing beyond that.
All right, thank you, counsel. All right, so I'm going to go ahead and set it on my typical 60-day discovery schedule. That will bring you back for a final pretrial conference date at the end of the 60-day period. And that date is going to be, my clerk is searching it now. That's going to be October 24th, 2022. And that's going to be at 9:30 a.m. You will receive a document in the mail from me, a scheduling order that allows for discovery that will be open through that date. And obviously you should move forward progressively. If you need something additional at that time, the court will certainly listen to your thoughts in that regard. Also, I want to point out that with regard to the scheduling order that you will receive, it will have a paragraph number 6 that provides for the opportunity to file and notice motions for hearing on the return date. That is October 24th, 2022, the pretrial conference date. You can notice motions and set them for hearing on that date. All that's required is that you make sure that the opposing party has at least 10 days to respond to any such motion. That language will be contained in the scheduling order. So notwithstanding court rules in this regard, dispositive and or non-dispositive motions may be filed. And all that's required is that the other side have at least 10 days notice prior to the hearing date, and the court will hear the motion on the 24th. All right, so you'll get a scheduling order from me in the next few days in the mail. I wish you well, gentlemen, and good day to you.
Thank you, Your Honor.
Have a good day.
Thank you, Jeff.
Thanks, Connor.
The court now calls case number 22-177199. This is Healthcare Imaging Partners versus City of Detroit. The matter is before the court, set on for a pretrial conference. Your appearance for healthcare, please, at this time.
Good morning, Your Honor. Andrew Bush, P84194, appearing on behalf of the plaintiff.
Thank you, Mr. Bush. Good morning to you, sir. For the City of Detroit, your appearance at this time, counsel.
Good morning, Your Honor. Philip Hiltner, P77913.
All right, Mr. Elman, good morning to you as well, sir. I do see that I had the discovery ended up under my order on the 28th of June. Somebody update me on the status of things at this point.
Yeah, Your Honor. So it appears that we've exchanged all the discovery that's been sent out and given the bills to the defendant, and we're looking to just settled the case now. I think all the documents have been exchanged and just in the mode of settling.
Has there been any offers of compromise or resolution at this point, or you just like a little time to try to go through that process? What's going on?
Just a little time to go through that process, I believe, Your Honor.
Yeah, I agree with that, Your Honor.
Very well. So why don't I take another look at it? 30 days reasonable?
Yes, Your Honor.
All right, so I'll take another look at it 30 days out. That's going to put us at
September the, I guess it'd be the first. We go later.
yeah, just a little bit later next week.
Yeah, 1, 2, 3, are you gonna try the 6th?
Yeah.
I mean, the 8th, I'm sorry.
The 8th? All right, 9/8. Excuse me, 10. Yeah, 9/8.
Yes. 9.
9/8/22, and I will set that over for 9:45 a.m. That will the court will indicate that is a review date. We'll see where things are at that time, if I need to set up anything beyond that point, like trial or whatever might be necessary. We'll see if you've been able to get some traction or perhaps getting it resolved. A good day to you, gentlemen. All right.
Thank you, Your Honor.
Thank you, Your Honor. Have a good one.
You too. The court now calls case number 22-242568. This is Jacqueline Miller versus Red Barn Enterprises. The matter is before the court. Looks like on the filing of a claim of appeal after the decision of a magistrate. Let me look a little bit further here and see what's going on. And I do see a counterclaim. I see a request for entry of default. Let's see what else is going on. All right. All right, let's get your appearances now. Do I have Jacqueline Miller on this Zoom? Say something if you're here.
I'm here.
All right, good morning to you, Ms. Miller. For the defendant, Red Barn Enterprises LLC, your appearance at this time.
Good morning, Your Honor. Sean Murphy here on behalf of defendant counterplaintiff Red Baron Enterprises LLC.
All right,
And I'm Rob
you're-
Gavin also.
Go for the record, counsel.
79255, Your Honor.
All right, thank you. Good morning to you, counsel. Are you counsel as well? Go ahead, sir.
I am. I'm Rob Gavin. I'm also here at Shipman and Carlson, P72726.
All right, thank you, counsel. Good morning to the two of you.
Morning.
So somebody update me. It looks like this is something that was removed from the small claims division. Then I see something that gave you some indication of an appeal. So the file is kind of all over the place. So somebody update me on where things are in regard to this matter.
Well, Your Honor, we haven't received any claim of appeal. I noted by the docket that that's likely what it was. My assumption is that she was appealing the decision to remove it from small claims. However, we represent a limited liability company, and you can't have counsel, nor can an LLC represent itself in small claims. So it's probably before the district court on the general civil docket.
Okay, so ma'am, let me ask you, Ms. Miller, is that what you're appealing, is the removal of the case to from the small claims division? Are you appealing that?
Judge, I only filed small claims. I haven't completed anything else. No appeal or no default, anything. They are the ones that moved it from small claims to civil division.
Yeah, I understand that, ma'am. Let me stop you. I have a document that says appeal of decision regarding removing it from small claims to general civil division. Did you challenge that decision to remove the case to the general civil division?
No.
Okay. All right. Well, that's a moot question then here, because I had to start there because obviously the law allows for the defendant and or the plaintiff to remove the case from a civil, from a small claims matter to the civil division. That's a procedural matter that is allowed under the various court rules. So that's why it's in front of me instead of being in front of the magistrate, because the defendants have asked that it be removed out of the small claims division into the general civil division. And one of the reasons for that is because in the small claims division, no attorney can be present to represent a party. And moreover, Red Barn Enterprise is a corporate entity, and that entity would have to be represented by an attorney under the rules of law in the state of Michigan. So I saw where there was a petition for entry of default. It looks like the plaintiff, the defendant is claiming that the defendant is claiming that the plaintiff is in default. Counsel, tell me about that.
Yes, Your Honor. So this claim was filed on April 7th. We asked for it to be removed on April 18th. It was granted on the 2nd of May. And then 10 days later on the 12th, we filed the answer, affirmative defenses, and a counterclaim. Under MCR 2.108A1, response was due to that on June 2nd, 2022, Your Honor. She has never answered it. It's been 82 days since we filed the counterclaim. We haven't received any response. So, we submitted the default request, and Your Honor, we'd ask that it be entered today.
All right, thank you, Counsel. Ms. Harris, they filed with the court a counterclaim against you alleging a breach of contract, alleging defamation, and further.
Excuse me, Judge. My name is Miss Miller.
I haven't asked you for anything yet.
No, I said my name is Miss Miller.
Okay, well, I'll get this.
I'm sorry.
I'll get that. I'm coming to you.
Oh, okay.
I'm more interested. If I said your name wrong, we'll get all that straight. I'm more interested in you being able to respond to a significant issue before the court relative to whether or not you received, number one, the counterclaim in this matter, and number two, that you respond to it. If not, why not? Tell me what's going on in that regard, man.
I received a letter from the attorneys, just as the court has, from where it was removed from the small claims to the civil division. However, I haven't received anything else except for the court date of August 12th, 2022.
All right, ma'am.
And that's all I've received from the court and the attorney.
All right. So there's a document entitled Defendant Counter Plaintiff Red Barn Enterprise LLC Counterclaim. You're indicating that you have not received that. Is that correct, ma'am?
No, I have, wait a minute, I got all the papers in front of me. I have their letter and I have the state of Michigan 36th District Court from the attorneys stating that there is a defendant counterclaim, plaintiff Red Baron Enterprise LLC's answer.
So the counterclaim part there is a complaint against you. Did you understand that?
I understood that, that the counterclaim, however, being that I am not an attorney, and they moved it to civil. I tried to get attorneys to assist me with this, but I couldn't get anyone. But at the end of the day, I didn't know that I would have to submit an answer to their claim, because I do have some paperwork that I brought in yesterday morning with all my evidence regarding their defamation and their claim. I also asked that, the court a while back to allow me to subpoena their records, because in their claim, they state that they had lost money and that I had damaged them. However, I didn't hear anything from the court for that.
All right. So yeah, you were required by law to respond to those allegations, ma'am, and not responding to those allegations results in a default against you regarding the claim that is being asserted. Let me ask you, counsel, what are you talking about when you talk about defamation?
Your Honor, this really stems from a fundamental misunderstanding.
Let
of
me,
Ms.
let me
Miller.
stop you for, let me stop you for a moment. Somehow, I believe, Mr. Galvin, I can hear you clearly when you talk, but for some reason, it seems that the other gentleman, Nelson, I'm sorry, got you. I think if you adjust to the microphone a little bit better, that may change things. So go ahead again, if you will, sir.
Yeah, Your Honor, can you hear me better now?
Yeah.
Okay.
Yeah.
All right, so this really results from a fundamental misunderstanding about the scope of work was going to be performed on Miss Miller's house. The project required 2 to 3 days, and the first part of it was doing some patchwork with plaster. So our client had a guy come out, do the plaster work. He had to let it dry overnight. He was going to come back out a couple days later and finish doing the ceiling work. Thereafter, Miss Miller began to complain that she wasn't going to pay just for patchwork, and then she refused to allow our worker to come back in to complete the project. She then got on, there's a Google review, and then there's one on Nextdoor, one of which she claims that our client preys on the elderly and that we took advantage of her. It was way out of line, Your Honor, and we tried to come back to finish the work and make it right. And she refused, and then she filed this claim after putting those reviews online. We sent her a letter asking her to take down these reviews as they were patently defamatory. We never got a response, so we responded in kind with a counterclaim.
All right. So to the extent, ma'am, that something may have been published, particularly in a public setting relative to a claim that this business is taking advantage of the elderly, that could sound in defamation. So it may not be, but it could. So here's what I'm going to do. I mean, you're held to the same standard as an attorney, even if you don't have an attorney. And that's the challenge that you have here. And so you have a certain amount of time in which to file a response to the pleadings, and you did not do that. In lieu of granting the defendant's petition for entry of default at this point, I'm going to give you 14 days to respond to the complaint in this matter, to the counterclaim, because you have to respond to that as required by law. But if you don't respond to that complaint within the next 14 days, I will grant the petition for entry of default and will grant judgment upon that default. That's a bit of extraordinary relief because the law does allow for entry of default where answer has not been timely filed. But under these circumstances, I will allow you a 14-day period to respond. So you'll have to get your answer in to that counterclaim. You would have to get your answer in on and before Wednesday, the 17th of August. That's gonna be a part of my order. So you gotta make sure that you get that filed with the court and served on the defendants in this matter. You have to respond to it. And so what I'm going to do is I'm going to go ahead and order that be done by August the 17th. I'm also going to set a new court date in this matter just shortly thereafter, so that I keep this in close proximity for the moment. If there needs to be discovery or something along those lines, we'll pick that up at a later point. If there's not an answer to the complaint or to the counterclaim, then obviously the default will be entered, the judgment will be entered on that default. I want to address that in the short term. All right, so you have until the 17th of August to respond to that, and then I'm going to bring this case back before August is out. Give me
August 31st.
All right, so the next hearing date is going to be the 31st of August, August 31st, 2022, and that's going to be at 9:30 a.m. All right, so make sure, ma'am, that you get that answer. You got to file it with the court and serve it on the other side by that date. Otherwise, the default is entered and a judgment will enter on that default. All right, and then I will review this matter on August 31st, 2022 at 9:30 AM. All right, and you'll get an order in the mail with that new date on it to return. But you got to note the date of the 17th of August as a date by which the order has to strike that, by which the answer to the counterclaim must be filed with the court and served upon the defendant counterclaim. All right, Ms. Harris, Ms. Miller, you had your hand raised now. Go ahead now.
What I wanted to say is that like I said, I brought in all that paperwork and get yesterday morning. Well, yesterday, not in the morning. So all I have to do is go in and file the the motion to answer.
Counterclaim.
Yeah, the counterclaim. And also I put in a motion to amend my amount also yesterday.
All right. I have
Your
not
Honor.
received that. It has not populated to the court's file. Counsel, have you received anything by way of a motion to amend as to amount?
No, sir, we haven't received anything in this matter, whether it's the claim of appeal. I see a subpoena on the docket. Her paperwork she filed yesterday, we haven't received any of it.
Okay. So you have to make sure that you send, listen to me carefully. It's understandable that it may not have populated to the court's file because you filed it on the second floor or wherever. Sometimes it takes a moment for it to catch up to the file. You have to also send a copy to the attorney. That is to the office, the attorney's office there on West 12 Mile Road. It's on the paperwork that you receive. Anything that you file with the court, you have to send a copy to the attorney's office. All right. The court doesn't send it to them. You have to send them. And when you file your answer, you'll file your answer with the court, but you have to send a copy to the attorney's office. All right, you understand?
Yes. Do they give me back the top form for the the form that you use to show that you're giving the court the answer?
Yeah, you can get a stamped copy of
Oh,
your
okay.
answer. And that's what's going to be important for you to get that answer time stamped by the court, so we'll know when you filed it. And then you want to send a copy right away to the plaintiff, to the defendants in this matter. You understand?
Yes, I understand. I understand.
All right, and counsel, of course, you don't have to react to any motion or petition that may have been filed. Given that you haven't received it, hasn't populated to the court. So I'll address all of that on the 31st, and then we'll be able to put some direction on where this case goes from that point. Right. So I wish both sides well. I'll see you on the 31st at 9:30 a.m. Good day to both sides.
Excuse me, Judge, one question. Did you get my request for the subpoena?
No, I haven't. How long ago did you file it, ma'am?
It was about a week ago.
Well, let me take a look. It doesn't seem like it's populated to the file yet, and we will definitely search out anything that you file with the court. But I don't have. Let me just look very carefully.
And I also emailed some videos.
All right, if you any of those things that you would do, those are like discovery items. You would not necessarily file those with the court, but you would want to make sure that the other side has a copy of whatever it is.
Oh, okay, I'll do that.
But I don't have those items in the file. If you file with the court, that means that they haven't populated yet. And when they do, they'll make it to the file. My trust is that all of those items will be there not later than August the 31st, when I have the next hearing on this, and we'll be able to drill down on each of these matters.
Okay.
All right, good day. Good day to both sides.
Okay, thank you.
Thank you, Your Honor.
All right, thank you. Good day.
Is that that upcoming court date for her is a review?
Well, it should be just a pre-trial.
Oh, pre-trial. Okay, all right.
would even say a pretrial and motion hearing for both of those.
Yes. Mhm. Yes, I don't even talk, I just received the word. Could be no communication. Yes, I have not. received that. So if you want to email it to me, you can, but we don't have. Latifa, L-A-T-I, as we write, A-H, dot Hunter, at 36 and 368. District Court. .org. No problem.